relationship between fundamental rights and directive principles. Relationship between fundamental rights and directive principles. Generally in UPSC, GS mains and also in Indian government and politics, this is a regular question. What is the relationship between fundamental rights and directive principles? Part 3 of the Indian Constitution deals with fundamental rights. Part 3 of the Indian Constitution deals with fundamental rights. Part 4 of the Indian Constitution deals with directive principles. Part 3 fundamental rights, Part 4 directive principles. Fundamental rights are enforceable in court of law. According to Article 13, if there is a law inconsistent with fundamental rights chapter, it is void. The Parliament shall not make any law which is inconsistent with fundamental rights chapter. So, fundamental rights are enforceable in court of law. Directive principles are not enforceable in court of law. According to Article 37, directive principles are not enforceable in court of law. Nevertheless, they are fundamental in the governance of the country. Directive principles are not enforceable in court of law. Nevertheless, they are fundamental in the governance of the country. Article 12 to Article 35 deals with fundamental rights. Article 36 to 51 deals with directive principles. Article 12 to Article 35 deals with fundamental rights. Article 36 to Article 51 deals with directive principles. Fundamental rights imposes negative obligations on the states. Fundamental rights imposes negative obligations on the state, like state shall not, no citizen shall. They mostly start with negative statements. Directive principles enforce positive obligations on states. They try to mandate the states to follow certain positive functions. For example, state to raise the nutrition, state to raise the standard of living, state to provide the living wage. These are all positive obligations. Fundamental rights are considered as civil and political rights. Fundamental rights are considered as civil and political rights. Directive principles are considered as socio-economic rights. Directive principles are considered as socio-economic rights. Fundamental rights are the means. Directive principles are the ends. Fundamental rights are the means. Directive principles are the ends. And there is a debate. Which is more important? Either fundamental right or directive principle. Which is more important? According to Justice Chandrachud, fundamental rights and directive principles both together constitute the core of the Constitution, the conscience of the Constitution. According to Justice Chandrachud, fundamental rights and directive principles both together constitute the core of the Constitution, the conscience of the Constitution. They both should be taken into consideration together. According to Minerva Mills versus Union of India 1980 judgment, Minerva Mills versus Union of India 1980 judgment, harmonious relationship between fundamental rights and directive principles. Harmonious relationship between fundamental rights and directive principles is a basic structure of Indian Constitution according to Minerva Mills judgment. And if you consider the background of the relationship between fundamental rights and directive principles. In the beginning, when our constitution came into force from 1950 onwards till 1971, when there is a conflict between fundamental rights and directive principles, fundamental rights were given a priority but not directive principles. When there is a conflict between fundamental rights and directive principles, fundamental rights were given priority but not directive principles. First case is Champakam Dorai Rajan case. In Champakam Dorai Rajan case, in 1950, Madras state government gave reservations to SCs and STs in medical and engineering colleges. Madras state government gave reservations to SCs and STs in medical and engineering colleges. Strictly speaking, giving reservations is against equality. Right to equality is a fundamental right. When you promise fundamental right of equality, giving reservations means you are treating some people specially, you are treating few people specially. And Champakam Dorai Rajan went up to Supreme Court saying that giving reservations for SCs and STs in medical and engineering colleges is against fundamental right to equality. Madras state government argued that state has to protect SCs and STs, and it gave reservations according to Article 46. It gave reservations according to Article 46. Special provisions can be made for SCs and STs, that is, state should protect the educational and academic interests of SCs and STs according to Article 46. And Article 14 is a directive, Article 14 is a fundamental right. Article 14 is a fundamental right and Article 46 is a directive principle. Supreme Court said, literally speaking, if you follow literal interpretation of the Constitution, 14 versus 46, Article 14 is enforceable in court of law as it is fundamental right. Article 46 cannot be enforceable in court of law as it is a directive principle. Article 14 can be enforceable in court of law as it is a fundamental right. Article 46 cannot be enforceable in court of law as it is a directive principle. So, from Champakam Dorai Rajan case till 1971, when there is a conflict between fundamental rights and directive principles, the court used to uplift only fundamental rights. The court used to take care of only fundamental rights. In 1971, 25th Constitutional Amendment was passed. In the year 1971, 25th Constitutional Amendment was passed. See, remember, from 1950 to 1971, when there is a conflict between fundamental right and directive principle, fundamental rights are important. Court used to give priority to fundamental rights. In the year 1971, 25th Constitutional Amendment was passed. 25th Constitutional Amendment added 31C to the Constitution, added Article 31 big C, capital C to the Constitution. According to Article 31C, when there is a conflict between fundamental rights and directive principles, two directive principles, that is 39 small b and 39 small c are prioritized. They are more important than 14, 19 and 31. Two directive principles, 39 small b, 39 small c are more important than 14, 19, 31. So, in the year 1971, by 25th Constitutional Amendment, Article 31 big C, capital C was added. Based on Article 31 capital C, it was inserted that when there is a conflict between directive principles of 39 small b and c and fundamental rights of 14, 19, 31, 39 BC prevail over 14, 19, 31. What is there in 39 B and C? 39 B and C are very crucial articles for equal distribution of wealth. 39 B and C speaks that operation of economic system should not result in the concentration of wealth. Operation of economic system should not result in the concentration of wealth, and ownership of material resources of the community should be used to subserve the common good. Ownership of the material resources of the community should be used to subserve the common good. See, country's resources belong to all people, not to the few people, and country's economic system should be useful for all, should be beneficial to all, not to the few people. Wealth should not be focused in the hands of few people. Wealth should not be concentrated in the hands of few people. This is 39 B and C. See, they are the articles which try to redistribute the wealth. They are the articles which try to make the economic system helpful to the common man. So, they are more important than Article 14, Article 19 and Article 31, said 25th Constitutional Amendment Act by inserting 31C. It is natural. Then this amendment making 39 BC important than 14, 19, 31 was questioned in Keshavananda Bharati versus State of Kerala 1973. This was questioned in Keshavananda Bharati versus State of Kerala 1973, saying that giving priority to directive principles is not good, but the court said giving priority to these two directive principles nobody can question, because these two directive principles are meant to promote welfare, economic welfare, thereby promoting social welfare. So, economic system should help to everyone, ownership of resources belongs to all, and country should operate the economic system for the benefit of all. There should not be concentration of wealth. So, nobody can question the integrity of these provisions, and they are very, very important, and when there is a conflict between 39 B and C, 14, 19, 31 should go out. Keshavananda Bharati's case said this amendment is right, correct. And later on, you all know in India in 1975 we have emergency. During emergency period, Indira Gandhi government made a very big constitutional amendment. During emergency period, Indira Gandhi government made a very big constitutional amendment, that is 42nd Constitutional Amendment 1976. 42nd Constitutional Amendment 1976. By 42nd Constitutional Amendment 1976, she has made a drastic change. So, she has again amended Article 31C, which was inserted by 25th Amendment. She has again amended 31C, which was inserted by 25th Amendment. You know now what the amendment said? Not just 39B and C, not just 39B and C, all directive principles are prioritized, are important than 14, 19, 31. By 42nd Amendment, there was a change in 31C. Till then 31C means only when there is a conflict between 39 small c, 39 small b versus 14, 19, 31, 39 B, C will prevail. But by 42nd Amendment, they have made a change in Article 31C and said all directive principles, all, that is 36 to 51, all directive principles are important than fundamental rights of 14, 19 and 31. So, 42nd Amendment by making a change in Article 31C have amended and said completely all directive principles are important than 14, 19 and 31. This change, that is making all directive principles important than fundamental rights of 14, 19, 31 was questioned in Minerva Mills versus Union of India. This change, making all directive principles, all, prevail over 14-1931 was questioned in Minerva Mills versus Union of India 1980. The court said this change which was made by 42nd amendment is wrong. This amendment which was made by 42nd amendment is wrong. The court said what the government have done by 25th amendment, what the parliament have done by 25th amendment, that is 39 BC are more important than 14-1931 is correct. But what the parliament have done by 42nd amendment, that is making all directive principles important than 14-1931 is wrong. So, the court said the earlier position, that is when 39B, 39C comes in, 14-1931 goes out. Even today that earlier position holds good. So, from 19 to 2019 there is no change in that. So, now even today Minerva Mills case said when 39 BC comes in, 14-1931 goes out. Not all directive principles prevail over fundamental rights, only 39 BC prevail over fundamental rights of 14-1931. So, this is the answer, relationship between fundamental rights and directive principles.